Hello, I'm Patrick Miyake, and I provide legal advice that helps public agencies in California achieve their policy and business objectives by figuring out a way to say yes to their questions. Every month, I will answer a legal question relating to governmental agencies. Now, on to this month's question.
Hi, Pat. We are a retail water agency and we are in violation of different rates and fines in light of the drought. Do we need to comply with Proposition 218?
This is a complex question, and different attorneys may have different views on the answer. As background, Proposition 218, the Right to Vote on Taxes Act, was approved by the voters in 1996, and it amended the California Constitution by adding Articles 13C and 13D. Proposition 218 established additional substantive and procedural requirements and limitations on new and increased taxes, assessments, and property-related fees and charges. In 2006, the California Supreme Court, in the Bighorn Desert View Water Agency versus Virgil decision, determined that water rates are property-related fees subject to the requirements of Proposition 218. Now, I will provide you with an oversimplified summary of my views on the different types of charges that may come into play in a water shortage emergency. Number 1, drought water rates. If your agency intends to adopt a new water rate structure with increased commodity charges based on the amount of water used, then Proposition 218 would apply to the proposed drought rate structure. Number 2, excess use charges. If your agency intends to adopt an excess use charge that is tied to the amount of water consumed, for example, by imposing a $1 charge on each unit of water used over a set allocation, then the excess use charge likely would be deemed a property-related fee and, therefore, subject to the requirements of Proposition 218. 3, a fine. If your agency intends to adopt a new fine that is not tied to the amount of water used, then I think there's a strong argument that the fine is not subject to the requirements of Proposition 218. For example, a fine of $50 for water use exceeding a set allocation, regardless of whether the exceedance is by 1 unit or 100 units, may not be deemed to be a property-related fee. This type of fine would be subject to Proposition 26, but it likely would fall within an exemption to the voter approval requirement. Again, this is a complicated area, so please be sure to consult with your agency's legal counsel before proceeding with any of these charges. Thanks for listening. If any of you watching have questions, please email them to me and I will consider it for a future segment of A Few Minutes with a Public Agency Attorney. We're adjourned until next month.